It needs to go red at the top left.
Does it? Okay. Hello, welcome to this week's Wednesday webinar. Birkett Long is offering a series of weekly webinars on a range of subjects for individuals, families and businesses. I'm Amanda Smallcombe and I head up the contested trust and probate team here at Birkett Long, and this is Lisa Cox, one of the solicitors in the team. This week we're going to be answering some frequently asked questions that people have about will disputes. Thank you for sending some questions in beforehand. We will be taking more questions as we deliver this seminar, so please do make use of the question and answer facility via the website. Lisa and I thought that before we go through the questions that we've got, it would be helpful for us to just talk you through some commonly used words and phrases relating to wills and the administration of estates, as you may or may not have come across them before. Sorry, can we have the next slide, please?
What does intestate mean?
So intestate is when someone dies without making a will.
What does the rules of intestacy mean?
So these are the rules that are set out by law which govern who's entitled to inherit the assets of a person who's died when they've died without leaving a will.
What is an executor?
An executor is the person that's been named in the deceased person's will to deal with the administration of their estate. I would just add that just because someone has been named as an executor, they don't necessarily need to act if they don't want to.
What is an administrator?
An administrator is someone who's responsible for finalising the estate of a person that died without leaving a will. There are rules around who can act as an administrator, and I'm going to come on to that actually during this webinar.
What is a personal representative?
This is the collective term often used for executors and administrators.
What is a grant of probate?
A grant of probate is a court document confirming that the executors named on it are the people that are entitled to deal with the estate. So when banks, financial companies, or even the land registry see the grant, they know that they are dealing with the correct people.
What are grants? What is a grant of letters of administration?
This is the court document, like a grant of probate, but it's where there is no will.
What is a grant of letters of administration with a will annexed?
This is the court document that's issued where there is a will, but there is no executor named on it, or the executor doesn't want to act, and so someone else is taking up the role of executor. Next slide.
What is a codicil?
So a codicil is an additional legal document which makes minor changes to a will. For example, changing who the executors are or changing the amount of a gift.
What is a beneficiary?
A beneficiary is someone who receives something from a person's estate. If there is a will, then the will maker will have chosen who the beneficiaries are. But if there's not, then the beneficiaries are those people entitled under the rules of intestacy.
What are chattels?
Chattels are any physical items that the deceased owned, and this can include things like household items, paintings, jewellery, vehicles, and so on.
What is a residue?
So the residue of the estate is what's left after all the estate's liabilities and debts have been paid and any specific gifts of money or items have been paid out.
What is a common law husband or wife?
Well, it's actually a misconception that if a couple live together for a certain period of time, that they are treated as if they are a husband and wife. So in fact, there is no legal status as a common law wife or husband. Next slide, please.
Okay, so we're coming on to the commonly asked questions and questions that you've asked. Can I get the first question, please? So can an executor change a will? So in short, no. an executor cannot change a will. It's the executor's responsibility to administer the estate in accordance with the will. If there is no will, then the personal representative must follow the rules of intestacy that we just mentioned, and that sets out how the estate should be distributed. It is important to note, though, that if the beneficiaries agree that they want the estate to be divided in a different way, other than what is set out in the will or what is governed by the rules of intestacy, it is possible to vary the terms of the will or those rules of intestacy after death under what's called a deed of variation. Now, if an executor doesn't follow the will or the rules of intestacy as they should, then they can be removed and possibly have to reimburse the estate for any losses or any incorrect distributions that they've made. Ultimately, that means that the beneficiaries who've been affected negatively by this should be recompensated. It is also really important to remember that executors do have a duty to provide an account of everything that's in the estate when they are requested to do so by a beneficiary. If they refuse to do so, an application can be made to the court, basically so that the court can order that an account be given to them and also to the person that made the application. So if you are concerned that an executor might not be progressing the administration of the estate, or if there's assets that are unaccounted for, such as shares in BT, for example, that you are aware that the deceased held but haven't been included in interim estate accounts, for example, then this could be an option for you. We'll move on to the next question.
Who can see a copy of a will?
So when someone dies, their will becomes the property of the executor they've appointed, and it's up to them, the executor, who they show a copy to. However, once a grant of probate has been issued, the will becomes a public document, and so you can carry out a search of the internet. There's a government website just as a member of the public, and you can obtain a copy of the will and the grant just for a small fee. Beneficiaries of a will have a right to information about their inheritance, so an executor must give them a copy of the will. An executor can blank out the other sections of the will that don't relate to that particular beneficiary to preserve the anonymity of the other beneficiaries and what they receive. So next question, please.
As the oldest child and next of kin, do I have a right to deal with my parents' estate?
This is a really common question we're asked, as usually the oldest child believes that they're entitled to deal with matters for the family, usually because family dynamics are such that the oldest is normally the one that's in charge, especially when it comes to siblings. However, the answer is that the role of next of kin expires on death, and the oldest child is not actually automatically entitled to deal with the estate. So when someone dies and leaves a will, it's the executor of the will that's responsible for administering and distributing the estate. If there is no will, the estate's distributed under the rules of intestacy, as we mentioned, and there's a list of people who can deal with the estate as an administrator in an order of priority. So this order of priority goes that first in line is surviving husband or wife. If there's none of that, then it's children of the deceased and the children of any child who died before the deceased. So the deceased grandchildren, in effect. If again, there's no one that falls into that category, it then goes to brothers and sisters of whole blood and their children, if any one of them predeceased. Then it's the brothers and sisters of half-bloods, and again, their children, if they predeceased. It then moves on to slightly less common people that would take up the role of an administrator, such as grandparents. If there's none of the people I've just mentioned, it's then uncles and aunts of the whole blood. And again, for that category, it's their children, if any of them predeceased. Then it falls to the Crown, and finally to a creditor. Where there's more than one person that falls within that category, then they are equally entitled to take up the role. So, for example, if there's not a surviving spouse and there were 3 children, all 3 of those children would be equally entitled to act as an administrator. So one, two, or even all three of them, really, if they wanted to, could take up that role of administrator. I would say that even though I've read out the order of priority, being the Crown and the creditor included, it is very uncommon for them to deal with the administration of an estate. That's because there are companies out there that can assist with tracing family members where family members are estranged or have just lost contact for one reason or another. Just while we're on this question, something that we do also get asked quite a lot is whether someone's attorney or deputy is acting as the executor. It's an understandable question, because if someone has been dealing with your loved ones, so for example your aunts, affairs for some time prior to their death, it is natural to assume that that person is going to continue on to its finality. But it is important to note that the lasting power of attorney and also the order appointing a deputy do cease to have any effect on death. So those people, the appointed attorney and the appointed deputy, don't have any authority to act, unless, of course, that attorney or deputy have been appointed as an executor under the will, or if they actually do fall into that category of people that can act as an administrator under the order of priority. What's the next question?
I have been left out of a will. What can I do?
Well, there's several avenues that you could investigate to see whether or not you might be entitled to an inheritance, even if you haven't been made, even if provision hasn't been made for you in the will. The first thing that we usually look at is whether or not the will is valid. So if you're concerned about that, then we can assist you on that. A will can be invalid on several grounds. If the will maker did not have testamentary capacity, if they didn't know and approve of the content of the will, if they made the will because of the undue influence of another person, if the proper formalities for making a will were not complied with, and unusually, perhaps if it was a forgery, maybe the signature was a forgery or the whole document was a forgery and the whole thing a fraud. So if a will is invalid, then the person's estate will pass under the terms of a previous will, or if there wasn't a previous will, the rules of intestacy. And therefore, a claim against the validity of the last will is really only of benefit to you if you were a beneficiary of a previous will or under the rules of intestacy, and that's the first thing we always think about. If there is no claim to set the will aside for invalidity, then we would discuss with you whether or not the Inheritance Provision for Family Independence Act applies. So this act allows a limited category of people to bring a claim against the estate, even if the will was valid or if the rules of intestacy fall into place. And what you need to show is that you fall into the category of claimants, that it was unreasonable for no provision to have been made for you either by the rules of intestacy or the will, and then you need to persuade the court that of a sum that would represent reasonable financial provision for you. For most categories of people, that provision is for maintenance need, except for the case of a spouse where you're not limited to a claim for maintenance. A really important point to make about claims under the Inheritance Act is that you should bring a claim, so you should issue your court proceedings within 6 months of the date of the grant of probate being actually issued. If you are thinking about a claim under the Act, then you need to get some advice quickly and deal with it quickly. If you're an executor or a beneficiary of a will, you may not know that somebody else is going to bring a claim under the Act for 10 months after the grant has been issued. And the reason for that is that whilst a claimant has 6 months to issue court proceedings bringing a claim under the Act, they also have another 4 months to actually provide you with copies of those court proceedings. We call it serving you with court proceedings. So as an executor, what you shouldn't be doing is is distributing the estate for 10 months after you've got the grant of probate, particularly if you think that there are people who might want to bring a claim. And finally, the other possible scenario where you could seek to claim an inheritance is by arguing something called estoppel. So estoppel arises where the will maker has made somebody a promise, and that other person has relied on that promise to their detriment, but the will maker has failed to honour that promise. So that's another circumstance. You do need very clear evidence of the promise, of your reliance on it, and you acting to your detriment. So you'd need very clear evidence about that. But certainly if you think you fall into that category, then please contact us. So the next question, please.
How do I stop someone dealing with an estate if I want to make a claim?
Okay, so if you're concerned that a will's invalid and you want to stop the estate being administered under the terms of that will, you can enter what's called a caveat. A caveat is a simple document that is registered with the probate registry against someone's estate, and that stops a grant of probate being issued for 6 months. The purpose of this is to allow parties to investigate the validity of a will. Naturally, these inquiries take quite a lot of time. Usually it's for people gathering evidence such as witness statements from the people that were allegedly the witness to wills, obtaining copies of any solicitor's will file for the creation of the will, or even obtaining copies of medical records. Because of that, it is possible to extend the caveat for another 6 months if necessary, and you can just keep renewing it if needs be to give you sufficient time to make those investigations. A caveat can only be entered where a grant of probate or a grant of letter of administration hasn't been applied for yet. But if it has, then don't worry, you can still take steps to prevent the estate being distributed before you make your claim, such as asking the executor to promise not to do so, giving what we refer to as an undertaking, or also just negotiating the terms upon which the administration isn't to be dealt with and the estate not to be distributed, pending you making your claim. I think we've got another question.
My parents are still alive, but I am concerned someone has influenced them to change their will. What can I do?
Well, I think the first thing to say is that a will obviously only comes into effect when your parents, their wills will only come into effect when they die, and so between now and then they may make another will, or they may revoke the will that you think they've made and you're worried about. But in any event, if you do have concerns, then you should keep a record of your concerns and gather any evidence that you've got, which may help challenge the validity of the will on the grounds that I previously discussed. So if they lacked capacity, evidence of undue influence, evidence that they didn't know and approve the content of the will, or evidence that the proper formalities weren't complied with. If you're really, really worried that they're being influenced, then my suggestion is that you contact social services and raise a safeguarding alert, because if your parents are vulnerable and they are being financially abused or influenced, then that's a matter for social services. If your parents no longer have capacity to make a will, then you could consider making an application to the Court of Protection for authority to make a will on their behalf. This could happen if their wishes have changed or their circumstances have changed since they made their last will. So that's something that you might want to think about if they don't have capacity anymore. So could we have the next question, please?
Who has the right to the ashes and to organise the funeral?
Sadly, this is a question that we've been asked a lot over the last year. I think just given the circumstances that we found ourselves in over the last year. Essentially, the executor appointed under the deceased will is responsible for planning and for paying for the funeral from the estate. If there is no executor, then it will be for the person who is taking up the role of administrator to do so. Now, whilst this is the legal position, it isn't always the case in practice, as the parties can agree to let someone else plan the funeral if it's more appropriate. So, for example, your loved one might have made a will appointing a professional executor, such as an accountant or a solicitor, maybe because they have a particularly complex estate. In those circumstances, it would probably be more appropriate for a family member to plan the funeral, just so that it can be more personal to the deceased. It is actually possible for the deceased to have left some wishes for their funeral in their will. So, for example, that they would like to be buried or cremated, or their ashes interred and scattered at a specific place, but these aren't actually legally binding on an executor. Now, in terms of the body, this is not treated as property, and so really no one has the right to own it. Instead, what the executor gets is the right to possess it for the purposes of dealing with it. If someone is cremated, then their ashes are left with the person who organised the cremation. And just with the deceased's body, there's no right of ownership of ashes, only a right of possession to deal with them. It's then for the personal representative to decide where to spread or inter the ashes. Usually this is a decision made with the rest of the family, but unfortunately disagreements can arise. And sadly, this is where we find ourselves contacted by people to ask, what can they do? It is possible to make an application to the court for an order as to how the ashes should be dealt with. Now, the court is reluctant to get involved with such decisions, but they will make a decision if it is necessary. Now, if they are asked to do so, the court would take into account the facts of the case and make a decision as to what they think is most appropriate based on the circumstances. Now, this does unfortunately mean that the personal representative's wishes, or the wishes of someone who is higher on the order of priority, for example, might not always be followed. There are some examples where the court has previously given a decision as to what's to happen with someone's ashes. One example is quite an unfortunate case of a 12-year-old that sadly died. He wasn't old enough to make a will, so he did die intestate. And because of that, under the order of priority, both mum and dad had the right to act as an administrator. Neither one of them could reach agreement as to what should happen with his ashes. Now, dad wanted them to be, I think, buried where he now lived. The mum and dad had divorced, which is probably why they couldn't agree. But mum wanted the ashes to be scattered where they lived as a family, because the boy's grandparents' ashes were also there. Now, the court in that case did decide that whilst mum and dad both had very convincing arguments, could completely see the rationale behind where they wanted the ashes to be, it was decided that the ashes should be scattered with the grandparents, because that was a place where they all used to live together, and it was really somewhere that they could all come together and have some focus. There's another similar case. Again, a boy was killed in a traffic accident. Mum and dad couldn't agree as to where the ashes should be interred. Even though the child was in the care of mum, it was only dad that was entitled to collect the ashes, because he was the one that signed the contract and the funeral directors were paid from by him. Thankfully, in that case, mum and dad were able to compromise and the ashes were separated so that both could have what they want. As you can probably imagine, these disputes are very difficult and by their very nature are sensitive. So we would recommend, if you do find yourself in this situation, to come and see a legal professional such as ourselves to get some advice that hopefully these situations can be resolved promptly for everyone involved.
And actually, the ones we've dealt with, it just instructing a lawyer takes the heat out of it a little bit.
Yeah, I think having someone else as a third neutral person, a neutral third party, it does take the sting out of it, because naturally people do just get their emotions involved in these things. They are emotional matters.
Yeah.
So I think that might be all of the
I think
questions.
that's the questions that we've had just beforehand, and actually we had some questions literally just before we went live, and we will come back to those and we'll find out if we've had any while we've been delivering the webinar. But just before we move to those, I just wanted to let you know that we are sending a recording of today's webinar out to everybody that registered for it, and that will be sent out tomorrow. We're going to include a link to a feedback form, and we'd be really grateful if you could fill that in so that we in future can provide you with webinars that are of interest to you. This is one of a series which hopefully you've been logging onto of Wednesday webinars. We're going to have a little break over the summer, and so our next webinar won't be until September, and that's going to be on employment law. It's quite a popular one, the employment one, for obvious reasons at the moment. If you are interested in our future webinars, then please visit our website to log on, or go to our Eventbrite page to sign up. That's up on the slides now at the moment. So just turning to some questions that we had just before we came on to deliver the webinar. We can just have those questions.
So how many executors should I have? And do you have any recommendations as to who I should and should not pick?
Okay, so this is really a question for one of our private client colleagues who would help you draft your will. But from a contested point of view, we would say choose people who are your age or younger, so that there's a chance that when you die, they are still around. Pick people who are honest, that you trust, and that know you well and know what you want. However, if the provisions of your will are likely to be controversial, then you might want to think about appointing a solicitor. Because if you, for example, appoint your spouse, who might be your second spouse and not the parent of your children from a first relationship, and there's likely to be tension between your spouse and your children after you have died, then it's really not a sensible idea to have your spouse administering an estate where perhaps they benefit and the children feel that they're not getting what they should get. So if there's likely to be controversy, our advice would be, from a contested point of view, don't appoint executors who are likely to have a personal conflict or a conflict with the beneficiaries. Appoint an independent who can actually act independently and neutrally. So that would be our advice from a contested probate point of view.
Yeah.
Has a person with a power of attorney got the right to change a will of the person they are an attorney for?
Yeah, this is a question that we have been asked before as well. It is important to note that when someone is an attorney for property and financial affairs, someone's will is their property, so the attorney does have a duty to safeguard the will. But what they don't have is the right to change a will for a person. That falls out with the scope of their authority. But what they can do, and in fact what anyone can do, is make an application to the Court of Protection, that Amanda, you touched on this earlier, for a statutory will to be made. So this is essentially asking their court to authorise and execute a will on behalf of someone that no longer has capacity, if in fact it is, in your question, in your example, that the donor, in this case, the person that made the power of attorney, no longer has capacity. There could be a number of different reasons for that. So for example, the person might have made a will gifting a property to someone, and in fact the property has been sold, so they would want to change their will given the sale of the property. That could be an example of when a statutory will might be appropriate, but I would say it is a very tricky question as to whether it is in someone's best interests for a will to be executed on their behalf, and that is the test, if it's in their best interests. And it is quite a complicated process, so we would definitely recommend that you get in touch with us to discuss this a bit further.
Yeah, it can be quite expensive as well because the official solicitor has to be involved. So it really has, the cost benefit needs to be right, as well as it being in somebody's best interest to make an application for book protection. But just to finish off every possible angle on this question, if you're an attorney for somebody and they still have capacity, you cannot make a new will on their behalf. They're the only people that can do that.
Yeah. Got any other questions?
So under my granddad's will, I was supposed to get £10,000. My father is dealing with the estate, but it has been 2 years and he still hasn't given me the money. Is this normal?
So it can take some time for the administration of an estate to be completed. The executor has to make sure that they're realising all of the assets. Because it's your granddad, you would have thought that your father knew what his assets were, but that may not be the case, and your dad has to have time to investigate the assets, realise them, and then pay the debts. That can take some time if there's assets abroad, or if there's a property in this country and it's been difficult to sell the property. The debts of the estate have to be settled before the estate can be distributed. And even if there's an application to the court criticising effectively the executor for your dad for not getting on with it, if it's reasonable that he hasn't managed to call in all the assets and settle all the estate liabilities, then the court won't order him to pay out even a legacy to you of £10,000. It really depends on how quickly he's acted in the circumstances. Obviously, in the last couple of years, we've had the pandemic, so there may be a reasonable reason as to why he's not dealt with that. The other thing I would say to you is, strictly speaking, there's something called the executor's year, and you should have received your legacy at the end of the executor's year of £10,000. Because you haven't, you will be entitled to statutory interest on top of the £10,000. So although you'll have had to have waited longer, you will get a little bit more. But if time slips on too much and your dad is just not dealing with the estate, or he's dealt with it but not just giving you the money, then that's something that you do need to come and get some advice about.
Should a will be read to the family at the wake, after the funeral, or at the solicitor's office?
This is a really common misconception that our friends in Hollywood have given to many of us, thanks to films like Knives Out, Harry Potter has a will reading in it, and also TV soaps like Coronation Street, EastEnders. You know, it's the classic scene of everyone sat at the solicitor's office, eagerly waiting to find out if their name's going to be read out to say if, you know, if they get the Picasso or some funds from the estate. So everyone does expect this to be quite a grand ceremony, but in fact there is no requirement at all for a will to be read out. As we've touched on in this webinar, the will does become a publicly available document once a grant's been issued, so you will be able to get a copy of it then, or if you're a beneficiary, you can ask to see a copy of the will prior to the grant being issued. You should be able to see it. What I would say is that it's also a good way to find out if you aren't a beneficiary, because if you ask for a copy of the will, the executor will need to tell you that you're not entitled to it because you aren't named in it. But yeah, very common misconception, that one.
Yeah, it is. Any other questions? No. Okay, I think there might have been a question that just came in just before the webinar about shares in an estate, and that's because we deal with disputed estates. That's not something within our remit. So what we will do for the person that sent that inquiry in was we'll get one of our private client colleagues to contact you with the answer to that question. We don't want to give you the wrong answer just because we're guessing. So thank you for joining us today. I think that's all the questions that we've had in. If there are any other questions that occur to you as a result of what we've said today, then please email us and we'll do our best to answer them. And just thank you for joining us today.